Okay, good afternoon, everyone, and thank you for choosing to spend your lunch break with us today. My colleague Irene and I are going to be steering you through the latest decisions out of the LAT and the courts, which have considered the definition of accident in the SABs. Now, since case law updates can sometimes be a bit dry, Irene and I have included lots of puns in today's presentation, which we hope you all enjoy, because we do. Before we hit the road, I do want to take a moment to introduce ourselves and the firm and cover some housekeeping points. You'll be seeing Irene on your screen momentarily. Irene articled with SBA lawyers in the 2023-2024 term, and we're thrilled she decided to stick around. She primarily practices in the areas of coverage, accident benefits, and property liability. My name is Shao, and I've been with SBA since its inception in 2018 by a majority female-led partnership. I primarily practice in accident benefits, priority and loss transfer, as well as coverage. Irene and I both work out of the Toronto office, but as many of you likely know, SBA also has offices in the Kitchener-Waterloo area and in London. And altogether, our 24 lawyers practice a wide variety of insurance litigation matters. So with that out of the way, let's map out today's route. Irene will be beginning with a quick refresher on the definition of an accident under the SABs and the test that's been developed by the Court of Appeal that the LAT and courts both apply when determining whether an incident was an accident under the SABs. Next, we will both be presenting a few cases from the last 2 years, and this portion of our presentation is going to include an interactive poll. We encourage everyone to participate. The more the merrier. We don't want you staying in neutral today. And finally, if time allows, we will end with a question and answer period. So please feel free to use the Q&A button that you can find at the bottom of your screen to send in any questions you may have at that time. With that, Irene, I'm going to pass the wheel over to you.
Well, so what exactly is an accident? As we're all aware, Section 3.1 of the SABs specifically defines an accident as an incident in which the use or operation of an automobile directly causes an impairment or directly causes damage to certain forms of property. This means that there is no coverage under the SABs unless the use or operation of a vehicle directly causes that loss. So in determining whether an incident is an accident for the purposes of the SABs, adjudicators and judges have generally applied the two-part test established by the Court of Appeal in the 3 cases shown on the screen here. Both parts of the test must be met for an incident to be considered an accident. So the first part of the first phase of the test, the purpose test, requires an insured to prove that the accident resulted from the ordinary and well-known use or operation of the automobile in question. The second phase, the causation test, requires an insured to prove both factual causation, so that's the use of the vehicle in fact contributed to his or her injuries, as well as direct causation, that the injury is related to or proximate enough to the vehicle's usage to be considered an accident. To date, the LAT has addressed the accident issue about 170 times, with only 1 in 4 cases not meeting the purpose test. So this means in most cases, the real issue is causation, specifically direct causation, which is a far more difficult test to meet. There's 3 guiding principles established by the courts to help us answer the direct causation question. These are the but-for consideration, the intervening act consideration, and the dominant feature consideration. While these principles were meant to provide clarity, as we'll see today, they can sometimes have the opposite effect, especially when coupled with the fact that the courts have repeatedly stressed that the SABs is a consumer protection legislation and must be interpreted and applied accordingly. One of the most common types of files where the question, was it an accident, comes up involves slip or trip and fall cases. So now I'll turn it back over to Shal, who will catch us up to speed on the case law in this area.
Thanks, Irene. Now, if you work in accident benefits, you're most likely familiar with the 2023 decision from the Divisional Court, Midori and Intact. This continues to be one of the most cited cases in decisions considering the question of whether an accident occurred. Briefly, Mr. Midori was inspecting and cleaning the roof of his camper trailer, which was attached to his truck in advance of leaving for a vacation, when he fell off and sustained some serious injuries. In applying the causation branch of the two-part test that Irene just mentioned, the LAT determined that while the trailer was the location of the fall, since Mr. Midori could not prove his fall was caused by tripping on some part of the trailer, the fall, or Mr. Midori losing his footing and falling to the ground, was an intervening act and the direct cause of his injuries, such that the incident would not meet the test for an accident under the SABS. Mr. Midori had appealed, and the divisional court overturned the LAT's ruling, noting that the link to be drawn is between the use and operation of the vehicle and the impairment. Mr. Midori did not need to prove a direct physical connection between the cause of his injuries and the vehicle. The court also cited several older FISCO cases with approval, which had concluded that the direct cause of the injury need not be the only cause. So now, keeping Midori in our rear view mirror, let's turn to the 2024 decision from the Divisional Court in Davis and Aviva. And this is going to include our first poll for your participation. So start your engines. The facts of the case are as follows. Miss Davis left work and she was walking to her car in the parking lot, holding her key fob in her hand, when she fell on some black ice about a foot away from her car and injured herself. The LAT adjudicator concluded that the slip on the black ice was an intervening event and the direct cause of her injuries, such that she was not involved in an accident under the SABS. And in doing so, the LAT adjudicator referenced the 2021 Divisional Court decision in Porter, which many of you may recall, involved a claimant who was walking down her icy driveway to get into a lift vehicle when she slipped and fell. Now, in that case, in Porter, the Divisional Court had found the ice was the dominant cause of the injury, such that the incident was not an accident. The court said it wasn't enough to prove a vehicle is involved. The vehicle has to be the direct cause of the injury. So turning back to Davis, Ms. Davis appealed the ruling to the Divisional Court. So what do we think the Divisional Court decided? Was it an accident? You'll see the poll screen pop up. Please feel free to hit yes or no. We'll give everyone a few seconds to answer the question before the results are shown. Right, fair 50-50 split. Let's find out. Half of you are correct. The Divisional Court said this was an accident. The Divisional Court distinguished this case from Porter, saying that where there is a distinguishing fact from a slip and fall and a series of events that connects the direct use of the car to the injury, the ice will not have played a dominant role or be seen as an intervening event. So in Davis, those series of events were that Miss Davis was holding her key fob in her hand with the intention to enter her car. That was the use and the purpose. And she was so close to completing that use of her vehicle that when she slipped and fell on the ice, part of her body ended up underneath her vehicle. So the Divisional Court specifically referenced Midori, reminding us that there doesn't need to be a direct physical connection between the cause of the injury and the vehicle. The court also noted another LAT decision, Sung in Cooperators, where the LAT had concluded a claimant who was loading his lunch bag into the vehicle when he slipped on ice was involved in the accident as defined under the SABS. Well, Aviva sought leave to appeal this decision, and the Court of Appeal denied leave. They released a very brief decision in December 2024, where they set out that this dispute is largely fact-specific, and Aviva had not made an arguable case for why the settled test for an accident under the SABS should be changed. Now, personally, and I feel like it's also for our audience listening based on the 50-50 results, the distinction between Porter and cases like Sung and Davis seem to be simply the claimant's proximity to the vehicle. And so I would say the test for an accident in ice slip cases is not quite settled. However, Davis is not going to be the case that brings us the clarity we probably all want, but maybe there will be one in the future, so stay tuned. I'm going to pass the wheel now to Irene, who's going to be cruising through some recent decisions released since Midori and Davis.
Thanks, Shell. So the first case we'll be looking at is the case in Wall and Aviva, which was a recent decision released January 2025. In this case, the claimant had parked his car in the parking lot of his building complex when he noticed the driver's side window had malfunctioned and would not close. He walked back to his apartment, but it started to rain a few minutes later, so he grabbed some garbage bags to temporarily cover his car window. While walking to the parking lot, he had the garbage bags in hand, and just as he was approaching his car, he slipped and fell on wet grass about a foot away from his car. So what do we think? Was this an accident or not? Okay, almost a 50-50 split. So let's see. This was in fact an accident. So half of you guys, or almost half of you guys, are correct. At the hearing, the discussion was largely focused on determining the dominant feature of the injuries. So the LAT followed the decisions in Midori and Davis and found that the claimant was injured during the direct use of his vehicle. The adjudicator reviewed the circumstances of the case and found them akin to the facts in Davis. So in this case, the claimant was approaching his vehicle to perform a repair when his leg gave way only about a step away from the vehicle. He had the materials in hand with the intention to cover the window. He was so proximate to the vehicle that he had used the curb under his bumper to help himself up. Given these set of facts and based on the causation test outlined in Midori and Davis, the LAT determined that the dominant feature of the claimant's injuries was an attempted repair of the broken window. So moving on, the next case I'll be discussing is somewhat of an unusual case. Porcadire and Personal involved an appeal of a LAT decision that was heard by the divisional court and released November 2024. In this case, the claimant had become partially paralyzed after traveling in her vehicle. However, the paralysis was the result of a spinal congenital condition, and the parties disagreed as to whether the stress experienced during the drive caused the claimant's blood pressure to become elevated, leading to hemorrhaging within her spine. And if so, whether or not that this amounted to an accident as defined in the SABs. So the stress on the drive was caused by some motorcyclists that had pulled in front of the claimant's vehicle, which was being driven by her husband at the time. And at one point, the motorcyclist had looked inside the passenger side window, which felt to the claimant like an altercation, even though there was no personal contact or any contact whatsoever between any of the motorcycles and the vehicle. Her husband had become very agitated and began driving aggressively, so the claimant took over driving. However, she began to experience pain in her back and lost sensation in her legs. And from there, her husband took back the wheel and drove straight to the hospital. At first instance, the LAT found that this was not an accident. The adjudicator preferred the evidence of the defense expert and specifically found that the injury would have occurred regardless of the vehicle's usage and that the vehicle was simply the location where the injury occurred. The LAT also found that the claimant's resulting paralysis was not a reasonably foreseeable risk of the sequence of events involving the motorcyclist and concluded that the vehicle was not the dominant feature of her injuries. So do you think that the divisional court agreed, or do you think they decided that this was an accident? Right. Give you guys a moment to respond. Okay, most of you guys said not an accident. This one was actually a trick question because the court didn't actually come to a final determination about whether or not this was an accident. It instead allowed the appeal and sent the matter back to the LAT for a fresh hearing. which has yet to take place. Just briefly outlining the court's decision, the court found the LAT's analysis of the competing expert reports was so unsound that it rendered the decision on the but-for analysis unreasonable. It also found that the motorcyclist had drove aggressively and that this was a normal risk created by the claimant's use of the vehicle. And it was incorrect for the tribunal to have found otherwise. In applying the dominant feature test, the court relied on Davis and concluded that absent a proper finding that the hemorrhaging caused the paralysis, the question of whether her medical condition would eventually result in the hemorrhage is neither here nor there. Now I'm going to hand the wheel back to Shell, who will take us through a couple more recent cases.
All right, so next up we have the case of Michelli and TD Insurance. This includes a coffee spill in a car, and I know these cases are always interesting. So Miss Michelli was a rear passenger in a vehicle being driven by her husband. They went through a McDonald's drive-through, ordered several items. She ordered an extra large black coffee. Her husband got the coffee from a McDonald's employee and then passed it back to her. When he did, the lid popped off and the hot coffee started to spill on her hands. And she reacted by dropping the cup, which fell into her lap. And then she sustained serious burns over various parts of her body. At first instance, the LAT adjudicator concluded that the unsecured lid in this case was an intervening event, breaking the chain of causation, such that the incident was not an accident under the SABS. Ms. Michelli eventually appealed to the divisional court, and they released their decision in January of this year. And what do we think they decided? Was this an accident? Give everyone a few seconds. All right, results are in, and 62% of you say yes, 38 say no. Let's see. 62%, you guys are correct. So yes, this was an accident. The majority of the divisional court's decision referenced the 2017 Ontario Court of Appeal decision in Dittman and Aviva, which also involved a coffee spill causing injuries when a claimant obtained a coffee through a drive-through window. So in Dittman, the Court of Appeal upheld the decision of the motions judge, who said that an intervening act will only absolve an insurer of liability if the act cannot be fairly considered a normal incident of the risk created by the use of the car. That a beverage obtained from a drive-through by a person in a car might spill is a normal incident of the risk created by the use of the car in that instance, and not out of the ordinary course of things. So the spill cannot be an intervening act. In Dittman, they also noted the fact that the insured was seatbelted in their car also added to the nature of the injury, considering they couldn't easily take evasive actions to avoid the hot liquid, like they might have if they weren't in a car at the time. In Dittman, the motions judge provided examples of what would constitute an intervening act that would break the chain of causation. And this would be, for example, if the drive-through employee threw the coffee at the customer and that's what caused the injuries, or if the customer got sick because the coffee was contaminated. So turning back to Michelli, the divisional court found that Dittman applied squarely to the facts and concluded that it was because the claimant was in her car at a drive-through that she experienced the inadvertent spill and was unable to take the evasive action necessary to avoid the consequences of the spill. Therefore, it was an accident under the SABS. Next up, we're going to review the LAT decision of Massad and Surtis. This involves a fairly unique fact scenario. So Miss Massad was riding with a group of bicyclists, including her husband. However, they were all fairly spread out, and she would later state that no one was around her when the accident occurred. She was riding downhill on a two-lane road, which was separated by a yellow center line, and she was going quite fast at about 50 kilometers an hour. She had a fall on the gravel shoulder of the road and sustained some very serious injuries, including multiple fractures, multiple lacerations, and loss of consciousness. She was taken to the trauma unit of a hospital and she underwent several surgeries. Her husband was told by other cyclists that the fall occurred when she lost control and went into the gravel shoulder off the road. So he repeated this to the hospital staff, And so the hospital records only referenced the bicycle accident. However, the claimant later informed Certis that her fall occurred because she had to veer off the road to avoid being hit by an oncoming vehicle that was driving erratically, and the vehicle obviously didn't remain on scene. Certis took the position that there was no evidence of this mystery vehicle and noted this version was inconsistent with the hospital records, which also stated it was a bicycle accident. So she she appealed the denial of her AB claim to the LAT. What do we think the LAT decided? Was it an accident? Give everyone a few seconds, get your answers in, yes or no. Okay, 61% of you say yes, 39% of you say no. Let's find out. Yes, this was an accident, is what the LAT said. So this decision largely came down to credibility. So the LAT stated that evidence corroborating the claim about the vehicle was not required. Her testimony was enough, and they found both Miss Masad and her husband to be credible witnesses. They said it was understandable the hospital records did not mention the vehicle, as they only had the husband's version at the time, and he didn't witness what happened, and he was just repeating what he had been told by others. They noted she would have been heavily sedated while in hospital, undergoing surgeries, focused on her recovery. And so relaying how her accident occurred or correcting how it occurred to the staff was not a priority. They also noted that once Miss Masad did relay how the incident or the accident occurred, her version remained consistent. So following Davis and Midori, the LAT noted there doesn't need to be a direct physical connection with a car to satisfy the causation test, and that a flexible approach should be taken when applying the causation test. The LAT noted that while slipping on the gravel shoulder may have contributed to the fall, it's the involvement of the vehicle, or a vehicle in this case, that was the catalyst, which ultimately led to her injuries. So as we approach the home stretch today, Irene's going to make a pit stop at two other types of cases where the question, is it an accident, frequently comes up. These are the areas of assaults and staged accidents. Over to you, Irene.
Okay. So in terms of assaults, the LAT will also apply the two-part accident test that we have been discussing today. However, it seems that the LAT has been relatively consistent and has generally found that assaults are not considered accidents for the purposes of the SABs. For now, it doesn't seem like the LAT has considered Davis in any of its recent decisions involving assaults. So it'll be interesting to see how adjudicators will apply Davis in these types of cases in the future. So one of the more recent decisions involving assaults is the decision in Addison and Intact. And this was a January 2025 decision. In this case, the claimant was sitting in his van. He had his ignition on, about to leave his house, when he saw a person running towards his van. He then opened the door to see what the person wanted, and the person hit him over the head with a baseball bat. The assault continued with the assailant jumping on top of the claimant while he was in the vehicle. And the claimant was eventually able to get his wife's attention by honking the horn and escaped his attacker. So the LAT ultimately found that this was not an accident, and the adjudicator determined the claimant had satisfied the purpose and factual causation tests, but found that he failed at the direct causation part of the test, as the assault was the dominant feature of his injuries. The LAT emphasized that it was not enough to show that the vehicle was merely the location of the accident or location of the injury, if the assault itself was the aspect of the situation that most directly caused those injuries. Here, there was no evidence that the use of the vehicle itself directly caused any of the claimant's alleged injuries. Next up, I'll be talking about staged accidents. The LAT appears to have also taken a relatively clear and consistent stance in confirming that staged accidents are not accidents for the purposes of the SABs. This is because the Insurance Act specifically excludes coverage for intentional acts. The LAT has also confirmed that staging an accident to claim accident benefits also constitutes a misrepresentation for the purposes of sections 52 and 53 of the SABS. Now, the assessment of staged accident cases is slightly different than the other types of cases we discussed, because the LAT will typically apply the principles set out in section 118 of the Insurance Act and sections 52 and 53 of the SABS instead of the two-part accident test. One of the more recent decisions involving a staged accident is the decision in Jevco and Militia. This decision was released in November 2024. In this case, the claimant had reported being the front seat passenger of a vehicle, which was driving through the intersection when it was T-boned by another vehicle who ran a red light. The insurer then obtained a police report which suggested that the claimant was not an occupant of the vehicle at the time. An engineer report was also obtained by the insurer, and in that report, the engineer had reviewed the event data recorder from the vehicle, which indicated that there were two impacts which occurred while the vehicle was stopped. The data further indicated that the front passenger seat was empty with its seatbelt fastened at the time of both impacts. The LAT found that the evidence as a whole supported that the accident was staged, and having determined the accident was staged, the LAT concluded that the claimant had made a misrepresentation and the insurer was entitled to repayment of any benefits paid and permitted to terminate benefits. All right, so now I'll turn it back to Shal to take us across the finish line and wrap up our presentation today.
All right, thank you. So everyone, we've reached the end of the road. So we're going to leave you with these key takeaways from today's presentation. Moving forward, we're going to see the purpose and causation test applied far more flexibly than it was in the past. And perhaps everyone watching noticed that from our polls, where almost all of the answers were yes, and the one that wasn't was a TBD. There can be more than one dominant feature for the cause of the injury for it to be considered an accident. In slip and fall cases, the focus is not going to be on whether ice or snowy conditions were an intervening act. Rather, it's going to be on what the insured was doing when they slipped and fell, and whether that was connected to the use of the vehicle. Finally, insurers should remember that credibility goes a long way in these cases. We saw this in the cyclist case, Masad, and it comes up in a few other of the recent decisions Irene and I covered. The LAT and courts have said that since the legislation does not impose an explicit requirement for corroborating evidence, it would be unfair to impose an evidentiary burden on a claimant in these cases. All right, so now we have some time for questions, and we'll take a look if any have come in. As a reminder, you're free to use the Q&A button at the bottom to send them in. As we wait to see if any come in, just also, if you think of something later on today or later on during the week, feel free to email Irene or I. We'd be happy to send you a response at that time. Appreciate all the hearts and thumbs ups that are coming in. Our presentation was so clear, there are no questions. Also, if anyone would like a copy of today's PowerPoint presentation, we're also happy to send that over if you want to just shoot us an email. Oh, after I said the thing about the hearts, I'm getting all sorts of emojis. It's wonderful. All right, so it's 12:29, so why don't we wrap up? This webinar has been recorded and it's going to be uploaded to SBA's website by next week. If you want to return to it later or forward it on to your colleague, feel free to do so. Otherwise, thank you so much for joining us today, and we hope you enjoy the rest of your day.
Thanks, everyone.